The subcommittee will come to order. Today's hearing will focus on the U.S. Department of Transportation's commercial driver hours of service regulations. July 1st, property-carrying commercial drivers will be required to meet new hours of service regulations that will have significant impacts on a large segment of the trucking industry. Truck drivers will be required to take a 30-minute rest break every 8 hours and will be able to restart their hours of service clock only once a week by not driving for a 34-hour stretch that includes 2 1 a.m. to 5 a.m. periods. The FMCSA promulgated these new regulations in December of 2011 with the intent to promote safety and to protect the health of drivers. By allowing drivers ample opportunity to get the proper amount of rest, the regulations are intended to help reduce crashes by reducing driver fatigue. Finding the right balance between providing drivers the opportunity to rest and the flexibility to account for unanticipated delays during the workday has been a challenge. Since Congress directed the Department of Transportation to issue a rulemaking on commercial driver hours of service in 1995, the regulations have been in constant litigation, which has led to confusion among the trucking industry and the enforcement community. Every stakeholder that is impacted by hours of service regulation has passionate beliefs on the correct way to implement them, and it's no wonder that litigation has persisted. The regulations that take effect on July 1st are currently being deliberated by the U.S. Courts of Appeal for the District of Columbia Circuit. The real-world implications of these new regulations are difficult to predict because of the diverse nature of the trucking industry, and I am receptive to the concerns of many of my constituents who argue that a one-size-fits-all approach won't provide the flexibility some companies need to take the appropriate rest breaks. For example, I've been asked if a driver is resting in a chair while waiting for a load to be unloaded or for some other reason and is technically on duty but undisturbed for 30 minutes, why can't such a break be counted toward the 30-minute break requirement? Some specific trucking operations, such as oil field equipment operators, have a special exemption from some provisions of the hours of service regulations. Why not others with similar operating characteristics? We most frequently hear concern where driving is just one small part of the overall job responsibilities, and not the long-haul drivers who are away from home for several days at a time. For instance, I've heard from hundreds of drivers in my state of Wisconsin who transport materials and equipment for highway construction who drive only 2 or 3 hours during a work day, but seemingly will be very much affected. Not only will the drivers themselves be impacted, but how our highway projects are completed will be affected as well. We'll hear more about these specific concerns from one of our witnesses today. I hope today's discussion will focus attention on these issues and potentially lead to proposals that allow drivers to efficiently complete their jobs without compromising safety. And I'm sure that safety is the primary goal of all of today's witnesses. The effective commercial driver hours of service regulation will help reduce fatigue-related truck crashes and save lives on our nation's highways. I hope today's hearing will provide our committee members with insight into this important national safety issue. I look forward to hearing from our witnesses and recognize my colleague, Mr. DeFazio, for any opening statement he might wish to make.
Thank you, Mr. Chairman. Mr. Chairman, I think the common ground here is, and I don't think anyone will disagree, that we want to prevent fatigue-related accidents. But getting to that point using the best data available, the best science available, seems quite difficult and torturous. As I was walking in, I walked by some staff and I said, if any of you can explain to me the new hours of service rule in 30 seconds or less, I'll give you a gold star. And they just kind of laughed because I've struggled with the restart and anyway, it just goes on and on. I understand what FMCSA is trying to do there in terms of both protecting safety and providing flexibility. It's a very, very difficult kind of combination. I would observe, as I have previously, that one of the most neglected and disturbing causes of people driving over hours of service is basically you have a lot of people who are paid by the load and not by the hour in this industry. And they are an external diseconomy to the people who actually provide for the warehousing and other things of goods, i.e., it doesn't cost them anything if you have to sit there 8 hours, and they don't care. And we used to have rules regarding detention time. We don't. I think we should go back to having rules regarding detention time. It would give us a much more efficient system overall. It would give us a safer system overall, and there would be a lot fewer people tempted to or forced to drive over their allowable hours of service if we could have just-in-time delivery or close to it at the warehouses and other places. So I'm hopeful that we will broadly address these issues today, try and find a place that makes sense. Because, I mean, right now, I mean, we've got one side, the safety advocates, suing because a rule they believe is overly permissive. We have the industry suing because they believe the rule is overly restrictive. The courts have ruled twice in favor of the safety advocates. Who knows what they'll rule this time. And FMCSA is going ahead with implementation before the judgment of the court, which I thought, I've got to disagree with some folks. I thought it would have been prudent to wait and see. But that's where we are today. That's what people have to address on this panel, and I really look forward to some of you sorting this all out for me. Thank you, Mr. Chairman.
Thank you, and I'd like to welcome our panel and thank you for the prepared statements that you've submitted. Invite you to, oh, yes, excuse me, Mr. Shuster.
Thank you, Mr. Petri. I thank you for holding this hearing today, and thank our witnesses for being here today. The new hours of service regulations that go into effect July 1st are something that we as the committee need to fully understand how they're going to be implemented, because it has significant impact on the trucking companies in this country. As Mr. Petri mentioned, I think this is a one-size-fits-all approach to safety, and while safety is paramount to all of us, whether we're here in Congress or whether we owners of trucking companies. I know Mr. Stocklin here and Mr. Williams, who run trucking concerns. If they're good business people, safety should come first, and it does come first. So again, we need to focus on that, but also make sure that when we're implementing new rules and regulations, that we let the science drive it, not a knee-jerk reaction to something that happened, last year or 2 years. But when I look at the statistics since 2005, the numbers have been steadily declining on fatalities and accidents. So that's something we ought to make sure we put into the equation. There was mentioned there are some exemptions for some of these operations, whether it's emergency services and disaster or oil field and others out there. But again, this committee needs to make sure that we fully understand how we're going forward. There are new technologies out there also. I was at Mack Truck in Hagerstown, Maryland, and they let me drive a truck which was not on the highway. So for all those concerned about safety, know that I was not in the flow of traffic. But it was an automatic transmission, which the folks at Mack told me it causes less fatigue on drivers. They not have to fight the clutch and the stick. So, I hope that's something we're looking at. And they say they're selling more and more of these because they're to attract a different kind of driver. It's less intimidating to some folks that otherwise wouldn't drive a truck. And so, again, I hope we're looking at those new technologies and taking that into the equation, because as I said, there's less fatigue to a driver. And of course, another great concern of mine, whether it's on this committee or any committee in Congress, is the growth of the fourth branch of government, and that's the federal bureaucracies are they're gaining more and more power, with Congress having little to say in these matters. So our oversight is going to be critical to make sure that we, as the elected branch of government, make sure that we don't allow the bureaucracies to overregulate and do things that are going to cause great harm to this economy. Statistic I saw in 2007, while the Congress passed 138 laws, the federal agencies put forth over 2,900 new rules and 61 significant regulations without Congress or without many stakeholders having much to say about it. So again, this is a great concern of mine. I know we're going to have aggressive oversight to make sure that these rules don't overstep their bounds, that they certainly want to make sure that they provide safety to the traveling public and on our highways. But again, it should be based on the science and not based on an emotional play here. So again, I thank the Chairman for holding this hearing and yield back.
Thank you. Our panel of witnesses consists of Administrator Ann Ferro, who is the Federal Motor Carrier Safety Administration representative, Mr. Stephen Williams, Chairman and CEO of Maverick USA, Inc., on behalf of the American Trucking Association, Major Mark Savage, President, Commercial Vehicle Safety Alliance, Mr. Edward Stocklin, President, Stocklin Trucking, on behalf of the Owner-Operator Independent Driver Association, and Ms. Joan Claybrook, Consumer Co-Chair, Advocates for Highway and Auto Safety, former Administrator, National Highway Traffic Safety Administration. Welcome to all of you. With unanimous consent, your full written statements will be, Mr. Jeffrey Dean Hinkle, who's Transportation Manager, Chandler Concrete Company, Inc., on behalf of Ready Mix Concrete Association. Excuse me. And again, by unanimous consent, your full statements will be made a part of this record. We'd invite you to summarize them in approximately 5 minutes, and to help you do that, the green light turns yellow a minute before the 5 minutes are up. And we'll begin with Administrator Ferro.
Chairman Petri, Ranking Member DeFazio, Chairman Shuster, members of the subcommittee, thank you for inviting me today to discuss how changes to the new hours of service rule will improve safety on our roadways and ultimately save lives. The top priority of the Federal Motor Carrier Safety Administration is safety. While the number of people killed each year, as the Chairman indicated, those killed in large truck crashes has in fact fallen significantly, in fact almost 30% between 2000 and 2011, from 5,282 to nearly 4,000 again in 2011. This number is still unacceptably high, and it shows there's still more work to do. Every life is precious. One life lost is one too many. In 1995, Congress agreed. They directed this agency to revise the current hours of service rule to reduce truck-related crashes and fatalities. A leading factor in truck crashes is fatigued drivers. And under the hours of service rule, drivers operating large trucks can work extremely demanding schedules, including working up to 80 hours per week and 14 hours per day. These extreme schedules increase the risk of fatigue-related crashes, and they do lead to long-term health problems for drivers. The hours of service rule that will be fully implemented on July 1 makes reasonable and common sense changes to reduce the number of fatigue-related crashes, the risk of chronic fatigue. These changes include limiting the maximum allowable work week from 82 hours to 70, restricting the use of the 34-hour restart to once in a week or once in 168 days, and requiring a very reasonable 30-minute break at some point during the first 8 hours of a driver's shift. Most of the industry's truck driving workforce, in fact 85%, will see little to no change in their work schedules. However, those drivers working the most extreme schedules, that schedule that can go up to 80 hours in a 7-day period, are the ones that will, in fact, certainly feel an impact by the changes in this rule. FMCSA developed this rule through an unprecedented level of transparency by engaging all sectors, including business, the safety community, advocates, drivers, business owners, shippers. We included recommendations from our Motor Carrier Safety Advisory Committee, which is a working group cross-representative of industries, law enforcement, labor, and again, safety. We also included input from thousands of stakeholders, drawn not just from comments submitted during the comment period, but from 5 listening sessions, an unprecedented number of listening sessions for any of our agencies held across the country. And finally, we incorporated years of peer-reviewed safety studies and research into finally crafting this complete rule. This high level of public engagement does contribute to a very balanced rule, a rule that provides a net gain in public safety and driver health, including savings of $280 million from fewer crashes, $470 million from improved driver health. And most importantly, the rule will result in important safety benefits for the American public, including saving and preventing an estimated 1,400 crashes, 560 injuries, and saving almost 19 lives. Our work did not end when this rule was published 15 months ago. We're working with industry and law enforcement to implement these changes. On FMCSA's website, you can find resources such as training materials, a guide to the new hours of service rule, very clear and robust examples of hours of service logbooks under the new rule. And because of our efforts, the earlier changes that took effect in the rule, by the way, changes did take effect within a month of this rule being finalized almost 15 months ago. Those changes went very smoothly, and we're confident that the changes we're talking about today will also go very smoothly. Overall, this is a very important tool to advance our fundamental safety mission and our solemn responsibility to protect the public and save lives. After all, our citizens deserve no less. Mr. Chairman, members of the committee, I'll be pleased to answer questions as the hearing progresses. Thank you.
Thank you. Mr. Williams.
Chairman Petri, Ranking Member DeFazio, Subcommittee members, thank you for this opportunity. As a safety leader, I am here today to express ATA's concern about the changes to the hours of service rules and describe how these rules will impact my company, safety, and the economy. Since '03, when the framework for the current rules was published, truck-involved fatalities have dropped by 25%. And also a more recent ATRI analysis found a 31% drop in preventable collisions between '04 and '09, which begs the question, why was a change to the hours of service rule truly necessary? Well, one thing is clear. FMCSA's motivation to change these rules was not based on evidence of a real problem. FMCSA did not undertake its own effectiveness analysis of the 2003 changes to the rules, even though they represented the first substantial changes in over 60 years. FMCSA's purpose and need for regulatory action did not cite any research or data analysis showing a problem. And I can confidently tell you that the industry will lose operating flexibility and productivity, which will raise cost. And the rules will increase driver stress and frustration without the corresponding net benefits. Initial data gathered by ATA reflects the likely average productivity loss will range between 2% and 3%. This estimate is consistent with a recent Wells Fargo security analysis finding a likely productivity loss between 1.5% and 4%. This translates into $500 million to $1.4 billion annually lost in productivity. My own company's analysis of recent electronic logging data found that 30% of our drivers would be in violation of the next rest break requirement because their breaks were not 30 minutes consecutively long. 46% of our drivers did not meet the 2 consecutive 1 to 5 a.m. rest periods. These findings will cause Maverick to make operational changes that will affect my drivers and my business, and these changes are not warranted based on Maverick's safety performance nor that of the industry. It is also important to note that Maverick's drivers currently use the restart not because they have exhausted their maximum weekly hours, but to ensure that they have met a full set of weekly hours available to them the next week for future work schedules that can be unpredictable in the irregular route trucking. This type of use is common and was completely discounted by FMCSA. The agency erroneously claimed that only nighttime drivers who work extreme hours would be affected, when in fact, most drivers who use the restart do so in order to have the flexibility to manage future schedules. Maverick has trained its drivers and operation personnel and has spent conservatively more than $57,000 doing so, but our costs are going to be less than others relatively because of the technology that we employ. FMCSA estimated that training, reprogramming, and transition costs would total at least $320 million. Because FMCSA declined your request for a short delay, the industry will spend this considerable amount of money, though that the rule may be altered in court. It is difficult, bordering on impossible, to accept FMCSA's suggestion that offsetting benefits will result. Yesterday, ATRI published a new analysis entitled Assessing the Impacts of the 34-Hour Start Provision. This is the only analysis of its kind. ATRI used representative industry data and a far greater data set than used by FMCSA to test the validity of the agency's cost-benefit findings. ATRI replicated FMCSA's restart analysis using the agency's own methodology, and its findings contradict those of FMCSA. FMCSA's claim that 15% of drivers work more than 70 hours a week is grossly overstated, likely because their data was gathered from compliance reviews and safety audits. But carriers are typically chosen for compliance reviews based upon poor safety performance histories. ATRI also discovered FMCSA's analysis did not capture many other costs. By following FMCSA's methodology using representative data, including a small amount of weekly time lost, 15 minutes a week, for example, from impacts ignored by FMCSA, ATRI found a strikingly different outcome. Instead of an annual net benefit of $133 million, in fact, ATRI found a net cost of $189 million for a difference of $322 million. ATRI's findings call into question the credibility of FMCSA's analysis. Congress could help, but time is growing short. Congress could direct FMCSA to postpone the effective date of the new rules until the MAP 21 directed restart field study is completed and the results are reported to Congress. Maverick is actually participating in that study as one of 3 carriers. And Congress should require FMCSA to postpone any rule changes until it implements the mandate for electronic logging devices. There are good reasons to have this mandate in place first, and I'd like to elaborate on those in a Q&A if possible. Finally, I want to thank the Chairman and Ranking Member of both the Subcommittee and full committee for asking the Secretary to consider staying the new rule until 90 days after the Court rules in the pending litigation. Though denied, your request meant a great deal to those of us in the industry. Thank you, and I will be happy to answer any questions at the appropriate time.
Thank you. Major Savage.
Good morning. Mr. Chairman, Ranking Member, members of the Subcommittee, thank you for holding this important hearing and for inviting the Commercial Vehicle Safety Alliance to testify. My name is Mark Savage, and I am a major with the Colorado State Patrol and the President of the Commercial Vehicle Safety Alliance. The Alliance represents State, provincial, and Federal commercial vehicle safety officials responsible for the enforcement of commercial motor vehicle safety laws in the United States, Canada, and Mexico. We work to improve commercial vehicle safety and security on the highways by bringing safety and enforcement agencies together with industry representatives to solve problems and save lives. In Colorado, I am responsible for the commercial vehicle safety and enforcement program for my state. The troopers and officers who work for me will be enforcing these new regulations starting on July 1st. Regardless of our opinion on any given regulation, CVSA members will enforce the rules set forth by Congress and Federal Motor Carrier Safety Administration. We appreciate FMCSA's effort on the development of this rule to balance safety and commerce. The hours of service regulations are a critical component of commercial vehicle safety. There are 4 key principles that should guide the crafting of any regulation and its impact on safety: uniformity, clarity, enforceability, and science-based and data-driven. While CVSA is not equipped to comment on the science behind the rules, we are hopeful that as we gain experience with these rules, we will see an increase in safety and compliance. We view the new rules as fairly straightforward. However, we do believe the 34-hour restart provision, the 30-minute rest break requirement, and the new definition of on-duty time provide greater opportunity for concealment and misrepresentation of hours of service by drivers and carriers who are so inclined. These changes have the effect of shortening the driver's workday and work week, which may create more incentive for some to falsify. Furthermore, the new rules will require more time and effort from enforcement to identify inconsistency in concealed hours. The new rules will be more difficult to enforce roadside because the rules expand rather than reduce opportunities for concealing hours. In my written testimony, I have provided several examples to demonstrate where enforcement will have challenges with the new rules. The implementation of electronic logging devices will help to alleviate some of the concerns regarding the enforceability of the new rules. While it is true that a persistent driver might find a way to trick or beat the device, the provisions in MAP 21 call for more stringent certification and tamper-resistant requirements, which will make cheating the devices more difficult. CVSA continues to support the requirement for electronic logging devices for hours of service compliance for all commercial vehicles. The devices will help improve the enforceability of the rules. However, electronic logging devices will not address all of the enforcement gaps. Drivers should also be required to maintain supporting documents in the vehicle so the documents can be reviewed by roadside enforcement and compared with the information being recorded in the record of duty status or the electronic logging device. With no current regulation regarding maintaining supporting documents in the vehicle, the ability for inspectors to check the validity of records of duty status roadside is compromised. It is true that some of these violations can be detected during a compliance review. However, the roadside inspection program is designed to be proactive to help identify unsafe vehicles and drivers and get them off the road before there is a crash. If an inspector cannot detect an hours of service violation roadside, a driver who has exceeded his or her hours could be allowed to continue driving. Further complicating the matter is the priority for conducting compliance reviews is set in large part by results from previous roadside inspections. If violations are not discovered roadside, then that motor carrier might not be flagged for a review. In summary, while CVSA members will enforce the rules to the best of our ability, we believe the pending hours of service changes will continue to make enforcement more difficult, especially for those drivers and carriers who choose not to comply. While the hours of service regulations are designed to help the driver to obtain quality rest, each of the 3 new rules can be disguised or falsified. The rules have shortened the work period for some drivers, thus increasing the temptation to falsify their records of duty status. While we will not know for some time what impacts this ultimately will have on safety, we do know that without additional tools such as electronic logging devices and supporting document requirements, roadside enforcement's job will continue to be challenging, and those who seek to break the rules will have more opportunities to do so. Each year, there are approximately 3.5 million roadside inspections conducted in the United States. The roadside inspection programs identifies high-risk operators and removes them from the road before a crash occurs. If we do not have regulations designed properly or provide roadside enforcement with the appropriate tools to be effective at their work, the anticipated safety impacts will not be realized to their full potential. Last but not least, research by FMCSA has determined that in 2009 there were 573 lives saved from roadside enforcement activities conducted through the Motor Carrier Safety Assistance Program, which equates to about $3.4 billion in safety benefits. In 2009, these grants to the states totaled $162 million, equating to a 21-to-1 benefit-to-cost ratio. Clearly, the roadside enforcement program provides a remarkable return on our investment. Thank you, Mr. Chairman, for the opportunity to be here today, and I will be happy to answer questions at the appropriate time.
Thank you for your testimony. Mr. Stocklin.
Good morning. My name is Ed Stocklin. I'm from Warner, Washington. I've been a professional truck driver for 35 years.
Can you pull your microphone up closer?
Sure. Is that better?
Yeah, better. Thank you.
Okay. I've driven more than 2 million miles and have had hauled almost every imaginable kind of freight. Today, my wife, Michelle, and I own and operate Stocklin Trucking, where I haul over-dimensional loads. I'm also a member of Owner-Operators Independent Drivers Association, OOIDA, represents the small business truckers that are the majority of the U.S. trucking industry, with more than 90% of all carriers own 20 or less trucks. Half of the trucking companies are one-truck operations like mine. Thank you for the opportunity to provide truckers' perspective on hours of service, rules, and how upcoming changes will impact our ability to drive safely, efficiently, and profitably. The changes that start on July 1 continue to trend the reducing flexibility afforded to truckers. This makes it harder for us to meet many demands of customers, regulators, and on-the-road environment. To fully understand our perspective, it's important to recognize that the majority of truckers are compensated on a per-mile basis. Simply put, if wheels aren't turning, you aren't earning. Further, we can begin our 14-hour on-duty period. That clock keeps running unless we take 8 hours off and then in the sleeper berth. While it may be easy for you to wait out traffic, bad weather, or an accident because of an unstoppable 14 clock, the trucker does not have that luxury. Our situation is made even more complex by our operational changes. For example, planning a morning departure doesn't happen until the evening because the warehouse waited all day to load our truck. Our customer only takes nighttime deliveries. All of these challenges impact our ability to operate safely, efficiently, and profitably. Most flexibility does not mean allows truckers to drive when tired. It means to give us the ability to rest when we need and to drive when we are rested. Nothing should come in the way of me stopping to take a rest break, yet truckers are commonly placed between inflexibility and customers. Regulatory demands and demands that will only become more inflexible starting July 1. I generally haul from West Coast to East Coast and back. My oversized loads often prevent me from driving outside of daylight hours. Further, I also play an active role in loading and unloading my truck. This often exhausts my time available for me under the 7-day duty cycle before I'm able to complete my cross-country trip. Under the current rules, I'm able to restart that cycle whenever I need by taking a 34-hour break. This ensures I am well rested with enough time for my trip back cross-country. However, under the changes that start July 1, I will be limited to taking one 34-hour restart every 7 days. This means I will no longer be able to restart when I need to, and a restart may become an extended off-duty layover. Additionally, the 1 to 5 a.m. period are based upon my home time zone. When I am taking an East Coast restart, I will need to be off between 4 and 8 a.m., reducing my already limited daylight driving time. Needless to say, this completely changes everything, even truckers. As these additional restrictions further reduce a trucker's flexibility, the demands we face have only increased. Well, not only all demands are under DOT controls, all changes that start next month will make it more difficult for truckers to balance them and to operate safe and efficient and profitable business. While Administrative Ferro deserves credit for their efforts to examine the demands faced by truckers in more detail, they are not reflected in changes going into effect next month. OIDA supports rules that are flexible, allowing and encouraging truckers to rest when tired and to work when rested. This will provide an important tool for to balance the day-to-day demands and would be best improve highway safety. Thank you for your opportunity to testify in holding this hearing today. Questions, if you'd like to, anytime. Thank you.
Thank you, Mr. Stocklin. Ms. Joan Claybrook.
Thank you. Start again. Thank you. Thank you, Mr.
Could you pull it closer to you?
Thank you, Mr. Chairman. Mr. Chairman Petri, Ranking Member DeFazio, and Chairman Shuster, and members of the committee. I appreciate this opportunity to testify today on the Commercial Driver Hours of Service Regulation, last issued in December 2011, and currently in litigation. I am Joan Claybrook, former administrator of the National Highway Traffic Safety Administration and the consumer co-chair of Advocates for Highway and Auto Safety, a unique insurance company and consumer coalition dedicated to improving traffic safety. Truck crashes are serious and they are deadly. On average, over the past decade, from 2002 to 2011, large truck crashes each year have claimed 4,000 lives and injured nearly 100,000 people. Despite declines during the recession, fatalities and injuries have increased every year since 2009. This is the equivalent of a major airline crash every other week, all year long. Large truck driving is one of the most dangerous U.S. occupations, killing 547 drivers in 2011. The annual cost to society of large truck crashes is over $83 billion a year. But the public pays the biggest cost in personal loss and tragedy. In the audience today are representing thousands of families whose family members have been killed and injured by tired truckers are Jane Mathis of St. Augustine, Florida, who lost her son and daughter-in-law returning from their honeymoon when a driver virtually ran over their car in slow traffic. Daphne and Steve Iser of Lisbon, Maine, who lost their son and 3 friends when their vehicle, while stopped in a breakdown lane, was struck by a driver who had fallen asleep. And Larry Libator, whose son was killed when a truck driver fell asleep behind the wheel, crossed 3 lanes of traffic and plowed over the car in which he was on the shoulder of the highway. The problem of tired truckers is not new. Almost 20 years ago, the 1995 National Truck and Bus Safety Summit, organized by DOT with experts and stakeholders, identified driver fatigue as the #1 safety issue in the trucking industry. In response, Congress immediately enacted Section 408 of the Interstate Commerce Termination Act, requiring DOT to adopt necessary, quote, countermeasures for reducing fatigue-related instances and increasing driver alertness, end quote. Unlike strict rules and enforcement with fatigue in commercial air transportation, the government has done little to improve trucker fatigue. In 1937, truck drivers were exempt from the Fair Labor Standards Act, meaning the companies cannot be required to pay overtime. As a result, drivers are paid by the mile, not the hour like other employees in America, encouraging drivers to drive as far and as fast as they can. But despite almost continuous rulemaking and litigation since the late 1990s, after passage of this legislative mandate, the rules governing truck drivers got worse, not better. In 2003, the Department of Transportation increased the 10-hour limit on continuous driving to 11 hours, and that's 3 hours more than Americans are required to work in far less arduous jobs. And it allowed a recalculation of the limit on weekly hours of driving by instituting a 34-hour restart, essentially shortcutting the end of the work week rest and recovery period for drivers who drove up to their maximum weekly hours before the end of the week. The restart allows drivers to take off only 34 hours, or you might say a shortened weekend, and then recalculate drive-in hours with a fresh start, cramming 17 hours more driving into the week. This maneuver allows drivers to significantly expand their drive-in hours beyond the prior hard limit of 60 hours for weekly driving cap, or 70 hours for a driver in an 8-day schedule. Truck crash victims, citizen groups, the Teamsters, and others sued DOT and won 2 rulings from the Federal Court of Appeals overruling DOT in 2004 and in 2007. The subsequent 2011 final hours of service rule, which is about to take effect on July 1, 2003, failed to cut back the continuous hours of driving to 10 hours, which had been in place, by the way, for 70 years, and only minimally considered the restart issues. Even the Federal Motor Carrier Safety Administration estimates that about 13% of fatal truck crashes involve driver fatigue, which we think is an underestimate. The agency made only modest adjustments to the hours of service rule, which you've heard described. I believe that we can do better, and I think we know what it takes. These limited safety benefits of the current rule, compared to the size of the problem, are why other improvements are essential to protect drivers' health and protect the driving public. Studies have found that since the current HoS rule was issued, large numbers of drivers admit to being deeply fatigued behind the wheel. Nearly 48% of drivers admitted that they had fallen asleep while they were driving. Other historical research shows that the crash risk for drivers increases exponentially after 8 hours of driving and is at higher levels with more. And you know that if a driver nods off for even a second in those 11 hours of driving, it could result in a deadly crash. Cumulative sleep deprivation can only be overcome through extended periods of off-duty time for rest and recovery. And for all these reasons, we felt compelled to sue once again. We have several appendices in our testimony which are helpful, I hope are helpful to the committee, including excerpts from court decisions and a chronology, history of the rulemaking. Thank you so much, Mr. Chairman. Appreciate it.
Thank you. And last but certainly not least, Mr. Hinkle.
Chairman Petri, Ranking Member DeFazio, and members of the committee, thank you for the opportunity to share the ready-mix concrete industry's concerns with the upcoming changes to the Federal Hours of Service regulations. My name is Jeff Hinkle. I am the Transportation Manager for Chandler Concrete Company, a family-owned and operated ready-mix concrete company based in Burlington, North Carolina. Chandler Concrete Company was founded in 1946 and currently employs 380 people. We operate 40 ready-mix concrete plants, 256 commercial motor vehicles, deliver 655,000 yards of concrete annually, and have operations in North Carolina, Virginia, and Tennessee. Today, I'm also testifying on behalf of the National Ready-Mix Concrete Association, of which I'm the current Vice Chairman of the Operations, Environment, and Safety Committee. The current hours of service regulations our nation's commercial motor vehicles are operating under are not perfect. However, they are manageable and much more flexible for operations of the ready-mix concrete industry than the new impending hours of service rule changes. As with most small businesses, operating a ready-mix concrete company means there are finite amounts of resources
for everything, whether it's ordering inventory, hiring employees, dealing with an array of mandates, or in the case of hours of service, making sure our drivers are compliant with an already complicated and burdensome safety measure while trying to deliver a perishable product as soon as possible. Adding another layer of regulation to this only hinders the ability to run a successful business. Here's why the hours of service changes do not work for Chandler Concrete Company and the ready-mix concrete industry. The mandatory break of 30 minutes every 8 consecutive hours is by far the most overburdensome and difficult for the ready-mix concrete industry. Ready-mix concrete drivers typically spend far less than 50% of their on-duty time actually driving. The other 50 to 75% is spent at the plant waiting to be dispatched, at the job site waiting for the contractor to receive the concrete, unloading concrete, and performing other administrative duties. Companies need to have the flexibility to give breaks as the schedule dictates throughout the day. For example, a concrete delivery often takes more than 2.5 hours to complete. Concrete is a perishable product, needed on a just-in-time basis. Once a delivery is started, it must be completed or the concrete may harden in the truck, causing thousands of dollars worth of damage and potentially violating a delivery contract. Every day is different in the construction field. Thus, companies need the flexibility to deliver concrete when the customer needs it. Drivers also have a flexible start time, where one day they start at 7 a.m. and the next at 12 p.m. Ready-mix concrete deliveries do not happen on a regular 9-to-5 schedule, nor do concrete customers always plan deliveries. Often customers order concrete on an as-soon-as-possible basis. As well, by requiring this 30-minute break, which more often than not will be required to be taken as off-duty, non-paid time, this break ultimately keeps drivers away from their families longer and with no additional pay. Due to all of these factors, compliance with a 30-minute break unfairly affects the effectiveness of delivering ready-mix concrete and the practices of the ready-mix concrete business without improving safety. The ready-mix concrete industry has estimated industry-wide compliance with the hours of service rule change to cost roughly $268 million in the first year alone. This cost, in part, includes driver training, new technology, administrative expenses, customer complaints, additional fuel, hiring of more drivers, and buying of more equipment. In conclusion, the easiest and clearest solution to the problems outlined above is to reinstate the pre-December 2011 hours of service regulations. We should be smart enough to recognize unique industries and how these types of regulations unnecessarily adversely affect them. Again, thank you for the opportunity to comment on how the hours of service rules changes will affect Chandler Concrete Company and the ready-mix concrete industry. I'd be happy to answer any questions the committee may have.
Thank you. Thank you all for your testimony. The testimony of the last witness on the difficulty for the concrete industry, and I suspect asphalt as well, is reminiscent of previous hearings where we had people testifying on previous hours of service rules who were working for utilities, for example, driving to and then doing work. If you have a storm and wires are down, are they supposed to stop and let people stay in the dark, or should there be exception and some flexibility? And agricultural industry during harvest time and other times of year, it's very important that they not just stop and let crops rot or fail or whatever. The same thing evidently is true in the petroleum industry, where some exceptions have been granted, and I'm a little surprised that in the rulemaking process, I don't know if you failed to comment on it or if they just ignored the concerns that you. What?
The National Ready Mix Concrete Association did submit comments on the ruling. Okay,
I'd like to ask Mr. Savage, if you alluded to possible increase in enforcement difficulties with the new rules, and said your written testimony provides some concrete examples. If you could expand on that for a minute or two, it would be much appreciated.
Thank you, Mr. Chair. Absolutely. My written testimony provides several examples, I believe 3. I will briefly discuss one, and it's specifically related to the fact that we don't have the ability to check supporting documents. For example, the new rules allow or require a driver to take 30 minutes off before they reach 8 hours of driving. And currently, there's no requirement to maintain supporting documents. So a driver conceivably, if they were inclined to falsify their log, could go into a truck stop and fuel their truck. During that time that they were fueling their truck and checking their load securement, checking the truck, that time is supposed to be counted as on duty, not driving. The driver could conceivably log that time as being their off-duty time, and without us having the receipt for the fuel, we may not be able to determine whether or not that driver was actually resting during that 30-minute break.
Thank you. I think Ms. Ferro, I'd like to provide you an opportunity if you would care to respond to any of the other panel members' testimony.
And thank you for that opportunity. Two quick things I want to follow up on. Mr. Chairman, you rightly asked about special exceptions for certain industry categories, understanding that oil fields have certain special exceptions from hours of service. Agriculture has certain special exceptions from hours of service, as does the concrete industry. The concrete industry, and that was not changed under this rule that takes effect July 1. The concrete industry has the opportunity for a 24-hour restart at any point in time when they're operating on a job site. And of course, utilities also have a special exception for responding to emergencies. So I want to be sure that that is clear. It's a 24-hour within operations within a 50-mile radius, and it's something that Congress put in place some time ago.
I think what they've indicated to me is that the half-hour break is a real problem because the concrete could set or it could interfere with the process. They're dealing with a natural substance that's not going to rest for half an hour. It's going to keep on congealing or whatever, and the same thing with hot asphalt and so on. Could you comment on that or how that can be managed more effectively?
Absolutely, Mr. Chairman. I appreciate this opportunity with the hearing to comment because the 30-minute break is a very reasonable expectation. It's a 30-minute break within a 14-hour workday. In fact, if you work an 8-hour day in this industry, you wouldn't even be required to take the 30-minute break because it only starts if you're going to drive after that 8th hour. With regard to areas of confusion, and so again, this is a great opportunity to clarify, the 30-minute break can be taken by the driver at any point in time during that 14 hours, providing it happens before any driving occurs after the 8th hour of work. So in many cases, a driver might take, to maximize the use of that 30-minute break and just only have to use it once within a 14-hour day, they would optimally take it sometime between the 4th and 8th hour of working. In the case of the concrete industry, they might choose when that driver's on a loop back to the plant to pick up more product, to say, all right, go off duty, you know, hop in your cab, and this was a different change we made in the hours, and take a 30-minute break. You're off duty. You're not responsible for the load. We're not going to reload you until you've had that 30-minute. So there are certainly this idea of having flexibility. That 30-minute break is accessible throughout that day, but again, it's optimized if the driver takes it sometime between the 4th and 8th hour. And
Mr. Hinkle, would you care to respond at all?
Yes, sir. To optimize our work days in the summertime, you know, a 14-hour day is a normal day. Drivers get 10, 15, 20-minute breaks throughout the day, probably every couple of hours. So, you know, our biggest reason is to sit them down and take them off the clock for 30 minutes is going to be tough for us to deal with. When they go through the day, they don't deal with the fatigue that an over-the-road driver, you know, maybe driving 6, 8, 9 hours at a time. You know, they're constantly getting short breaks throughout the day. Maybe not 30 minutes, but, you know, 15, 20 minutes as such. So they don't reach the fatigue level that a driver driving a long distance would reach.
Thank you. Mr. DeFazio.
Thank you, Mr. Chairman. Since this is a subset of a very complicated issue, I'm almost grasping it. So in the aggregate case, it seems to me there's two things that might apply and might be within the capabilities of the administration. There is the exemption for the time a driver spends resting in a parked commercial motor vehicle may be considered off-duty time. If a lot of these guys or women are sitting in line just with the truck rotating so the concrete won't set up, and every once in a while they might have to move. I mean, I wonder if that would solve the problem if there was an exemption for you're not actively doing anything with the truck, but it's just rotating because you don't want your concrete to set up.
Well, that's where we've got to clarify the definition of on-duty and off-duty time.
Right.
Because
but that could help because, I mean, they really are in line here,
yes,
right?
Sir, that could help if they're waiting, 30 minutes. But then again, we don't know how long we're going to be waiting when we get there.
But that could take care of some of it. But the other issue would be, and perhaps Ms. Ferro can address this, I was kind of wondering about the 8 hours and 14 hours, and I'm thinking, wow, these guys, I mean, how are they taking care of bodily functions? And as he's pointing out, they are getting short breaks during those 8 hours or 14 hours.
Right.
What if those were, if they could aggregate those? If these guys are, they drive there, they get there with a truck, they know it's going to sit for a minute, they get 15-minute break back in the truck. I mean, what if you could aggregate those as opposing to saying in a lump sum? What does the research say about, because they all say, stuff I read says really short naps can refresh a person, like just nod off, and then come back, except if you're at the wheel, obviously. But what about allowing aggregation of these shorter breaks that people take, particularly in this industry, which is short-haul driving?
So back to Mr. Shuster's, Chairman Shuster's expectation that any kind of a rule for any agency is research-based, scientifically identified, defined, developed. When it comes to breaks, and the opportunity and all findings, whether it's in a standard manufacturing plant or in heavy-duty vehicle operation, a 30-minute break where the individual is completely off-duty from operations does in fact contribute to a much lower crash risk in that subsequent hour. That's what the research says. It's very clear. A semi-off-duty break, a little bit less of an improvement in reducing crash risk. The concept here is there's a clear safety benefit. I'm sure Mr. Hinkle also wants safety on the work site, given the kind of heavy equipment his operators are running. So that optimum break is one 30-minute break. It improves that driver's clarity, that operator's ability to respond quickly if there's an issue. One opportunity to consolidate a break is to take 2 of those 15 minutes he referenced and allow the driver to grab it when they're going back to the plant, when they're back to the plant before they reload. Another is to take the off-duty, as you described, and ask another driver, hey, watch my truck while it's turning. I'm going to be here for another 2 hours. Can you take 15 minutes while I take 15, and we'll split that time and watch each other's rigs? I suspect that also goes on at work sites. But at the core of this is the concept of improving the ability of that operator to be as safe and alert as possible in a very challenging work environment, understanding that everybody still needs the flexibility to get the job done. That concrete's very important to get poured.
Okay. Well, if the research is that definitive, I'm just not sure. I mean, you're saying there is some improvement with aggregated shorter breaks. You're just saying you don't capture the full benefits. I mean, did the research drill down to the level of short-haul driving versus long-haul driving in terms of those sorts of breaks?
I'll have to go back and check, and I will respond to that question.
Because, I mean, short-haul driving to me is very different attention span.
If I could respond real quickly, the research generally is not unique to operating a heavy-duty vehicle. It's any sort of heavy equipment operations. The research with regard to workplace safety reinforces under any kind of OSHA standard or OSHA research, NIOSH research, that in fact an operator that takes a 30-minute break off duty has the optimum opportunity to reduce any sort of accident risk within that first hour when they come back on duty. We do it all the time. The difference is that we're not operating heavy equipment, and the risks of us bumping into somebody aren't as severe as someone who's using heavy equipment.
If I could, just one other quick thing, Mr. Chairman. you know, again, I've been trying to puzzle through the restart, and Helena, who I didn't talk to when I said no one could get an award for explaining this fully, has done a very spiffy little chart here. And her conclusion here is that with the 34-hour restart, you could still get to over 80 hours in a week. And then what would happen would be your restart would move a couple of days every week, and it would back up through the week. But you still could be consistently driving more than 80 hours in a week. So I'm not even sure that this extraordinarily difficult to explain concept is accomplishing your stated goal, which is to prevent anybody or everybody from driving more than 80 hours in a week in consecutive weeks.
Well, if I might clarify, now, Helena is right. She gets to this stuff very quickly and very accurately. You can, in fact, under the new rule, run 80 hours, take the restart. Your next run will be limited to about 57 to 60 hours, and then you'll have to take a longer break before you can run back at 80. Again, the whole concept behind this rule is pretty straightforward. The vast majority of the industry operates very well and within any kind of reasonable expectation of driver fatigue and driver wellness within this current construct. It's that opportunity to stretch the margins under the current rule by using that restart to move the week in that creates the risk that a driver would run 80 hours, 34-hour break, 80 hours, 34-hour break, 80 hours, week after week after week. And that creates the condition of cumulative fatigue, chronic fatigue, which not only makes that driver a real risk behind the wheel, it also impacts that driver's health in the long term. What this rule does, it limits the use to one time, let's say within a 2-week period, you can use it. 80 hours you run, you take the 34-hour restart. Now your next week you're stuck at 57 hours to 60 hours. You have a longer break, and then you might resume again with a restart at the end of that longer break. So it reduces the risk that 80 hours is run week after week after week. We worked very hard to ensure that there was some flexibility still in this rule, recognizing the demands of the trucking industry.
Thank you. Mr. Shuster.
Thank you, Mr. Chairman. Ms. Ferro, in MAP 21, we put in the law that FMCSA shall conduct real-world field studies, and I know that Washington State, Washington State University conducted the lab experiment, recommended that the next positive, or strongly recommended, I should say, that the next appropriate step should be to conduct a field study. And I know the industry has recommended you put these off until we do a real-world study. So why have you decided not to postpone and perform this real-world study that it seems everybody thinks is a good idea?
We are doing the real-world study. We launched it as soon as Congress incorporated this into MAP 21 and MAP 21 was enacted. We began the work both to scope out and define and award a contract to carry out the field study. In fact, we actually had the first driver start under the field study conditions in January.
So it's not going to be concluded by July 1st, and you're going to move forward with these regulations without having real-world data.
Look,
what will you do if it comes back and it says something different? You'll change the rules. I think it'd be better off for all of us if we temporarily postponed and let the real-world study go forward.
I appreciate that perspective. Flashback 10 years ago, the 34-hour restart that the industry prizes so much today was developed through a lab study with fewer subjects and not field study. But it was identified as an improvement in efficiency, operations, and in fact, rest for drivers. So the model is not unique.
Well, Mr. Williams, do you share that view?
I would prefer to have the facts
Absolutely.
in front of us before we make the changes. Even though we've already spent the money, you know, the impact of it's going to be significant.
Right, and it's true. Let's have the real-world facts. The other question I have is, while we're looking at these, and certainly safety is, as I said, is paramount, but my numbers that I have say about 75% of the accidents that occur out there with trucks are not caused by the truck driver. It's by the passenger car that cuts them off. And these things are not going to look at that at all. And in fact, the CSA scores that impact the industry greatly, they don't differentiate between an accident which the driver was not at fault and somebody cut him off and that's what caused the accident. It seems to me that it's fundamental in our justice system that ought to be taken into consideration. I'm a truck driver, I'm well rested, and I'm unlucky because I get a passenger car every so often cuts me off. So how is that fair in the CSA scores to not differentiate between who's at fault?
We refer to this particular issue, Mr. Chairman, as crash waiting. I think the industry for a long time has called it crash preventability. And we recognize that in the analysis that we use through the CSA program to prioritize the carriers that are putting the highest risk to the public, we use all crashes. And the neutralizing effect is every carrier is treated the same. It's all their crashes. No one gets a break with regard to that.
That puts luck involved in it. Mr. Williams's firm may have some unlucky drivers, or wherever he travels, people driving passenger cars and pulling out in front of him and causing accidents. That doesn't seem to me to be a fair way to go about this. It's not a scientific way. If a truck driver is safe, he's safe. If a truck driver has 5 accidents and 0 are his fault, they're not his fault. So I just don't think it's a fair way for us to proceed.
So the important last sentence that I talked too long to get in is that we are studying the issue. We expect a report to be completed this summer to both examine how the agency can best gather information on preventability, non-preventability, or really that driver's contribution to the crash, and weight it accordingly for all crashes, about 100,000 crashes, or just on the 4,000 annual fatal crashes. And that analysis will be available for everybody to review this summer.
If it's not my fault, it isn't fair. If it's not my fault, I shouldn't be held accountable for that. I shouldn't have to be jeopardized my living. I shouldn't be jeopardized my company's well-being if I'm not at fault. And that's something we got to look at very, very seriously, because it is a problem. I hear from trucking companies all the time. The other thing I'd like to ask Mr. Williams and Mr. Hinkle, if you have an accident in your business, what kind of economic impact is that on you? Whether it's your fault or not your fault, an accident occurs.
Well, I mean,
how significant is that?
Well, it's something we'll obviously have to manage. We spend millions of dollars trying to prevent accidents. Right. Obviously, there's some recent research that's come out that the industry is generally maybe underinsured based upon statutory limits that were required, the minimums to carry, but suffice it to say that every event has the potential to be, aside from bodily harm, it's just the property damage alone is fairly significant.
Mr. Hinkle.
We take it very serious. I mean, we spend a lot of money in training, and anytime we have an accident, we do a very thorough investigation. If somebody needs to be retrained, obviously there's a cost as far as loss of equipment or, personal injury, anything like that. So, when you refer to the CSA crash score, I have to agree with you 100%. And we've had several of those incidents where our score's gone up, and we may have had 3 incidents in 6 months and 0 or any fault whatsoever to our driver, but we get the letter in the mail saying your crash date is, your score's too high, and what do you do?
Right. Well, thank you very much. I appreciate the witnesses.
Ms. Hahn.
Thank you, Mr. Chairman. I really appreciate us having this hearing. I think for all of us, this hearing is providing an opportunity to figure out how safety, of course, is a priority as we balance that with the truck drivers, the independent owner-operators, and business people across this country. And may I first offer my deepest sympathy to the families that are here today for your loss of your loved ones. Tragic stories which, we don't like to hear those stories. And I think everybody here will agree that we want to get to the point where we have less fatigue in our drivers. I represent the Port of Los Angeles, and I think Ranking Member DeFazio talked about drivers getting paid by the load, not by the hour. And I was told by many of my drivers in the area that sometimes one one drop-off of a load was sometimes 13 hours because of traffic conditions, because of the ports only operating certain hours. When I was on the City Council, I pushed to move more off-peak hours at our ports because I felt that made better sense for our truck drivers. And by the way, they don't like to be on the road with the rest of us drivers either. They don't think we know how to drive. And a lot of the accidents, I think, with our big rigs are caused by incompetent commuters on the road who don't understand what it takes to brake one of those trucks. While certainly these rules are meant to create less fatigue in our drivers, as we've heard, many of them are going to be unenforceable. We can't mandate that folks get 8 hours of sleep at night. I think there would be a lot of people who would wish that was true in their own lives. So what I was going to ask the drivers particularly, those who represent drivers and the drivers, you know, this is the Transportation Infrastructure Committee. We're really looking at the infrastructure in this country. Many of us are on a freight panel, and we're going to make recommendations for a national freight policy in this country. What besides rest, taking time off, getting more hours away from driving, what do you think we could look at in terms of our infrastructure, in terms of at-grade crossing, in terms of more off-peak opportunities at our ports across this country? What else could we do in Congress that might relieve the stress of drivers, might create a better infrastructure that causes less fatigue? Is there something we could look at besides just regulating your time away from your truck, your time resting, your time sleeping, that would actually make for a better driving environment, which we know ultimately would lead to less stress and fatigue? Any ideas? Yeah, I'd like to hear from Mr. Williams, Mr. Stocklin, Mr. Hinkle.
Well, first, I think we're all in agreement that we want to reduce fatalities. We want to reduce bodily injury. I mean, we're all on the same page. It's just a question of how we can get there. And I think the context of your question is really, really important, because we also need to understand that over the next 20 years, the economy will double in size. And however successful you are in our infrastructure investment, it's going to pale in comparison to the challenges that the infrastructure system is going to have. We're already, 20 years behind, and so we have a lot of catching up to do. And the reason that's as important is because congestion really creates an awful lot of challenges, not only for safety, but for the environment as well, not to mention the economy. So infrastructure, yes, more lane miles of highway is certainly important. But the fatigue is only one of the components of a good safety management system. On our fleets, we have about 1,500 trucks. They all have collision avoidance systems, lane departure alert systems, roll stability control, disc brakes. The list goes on and on, all the technology. We use electronic onboard recorders. I think that you ask what can be done, is we need to make sure that we get the mandate implemented on electronic onboard recorders, or the rest of this is really kind of irrelevant, not to be disrespectful. Because regardless of the rule that we have in place, if it's not enforced and that CVSA doesn't have the ability to leverage the resources they do have to ensure a higher degree of compliance, we don't have much hope of any progress. So the foundation from which all improvements can be made are the electronic onboard recorders. They're what rationalize me spending tens of millions of dollars a year to continue to want to grow my business. But without that confidence that there is some reason brought into the equation, it's really not prudent for me to continue to invest in all the safety technologies that we've already invested in. So I really truly believe that EOBR mandate, which we want to compliment, you all in the leadership role that you've taken on making sure that that became a reality, but we need to make sure that that's implemented as soon as it possibly can be. And I think that would be paramount over everything else. If I may also add, as a part of that, like hair follicle testing, we need to be allowed to use that. It improves safety. The Drug and Alcohol Clearinghouse, there are so many common sense things that are laying before us that we need to get implemented, and we need your all's help to get all those things done.
Thank you. Thank you. Thank you, Ms. Hahn. Mr. Crawford.
Thank you, Mr. Chairman. I appreciate you holding this hearing, and I want to thank the witnesses for being here, and particularly my fellow Arkansan, Mr. Williams. And I appreciate the work that you do. 33 years in the business, you've grown a Maverick Transportation, and you and your staff have done a fantastic job, and you're an industry leader in safety. So you alluded to this in your comments just now, but I want you to elaborate on why you believe EOBRs are so critical to the enforcement of the hours of service rules and collection of data.
We are, in the spirit of what we're trying to do here is manage with facts. We're trying to, as Ms. Claybrook said before the hearing, we are, we're all trying to get to the bottom and what are the real facts of the situation. And in fact, EOBRs, because we manage literally 1,500 trucks by the minute. We know how long it takes them to load, how long it takes them to unload. We know when we're waiting. We know where we're waiting. We know actual transit times. And that's one of the things that's those facts. Much like my concern over the 34-hour restart, for example, I can factually say my concern over us focusing on the elimination of 34-hour restart when, in fact, the concern is to mitigate the people that bump up against the 70 hours. And year-to-date, my fleet, which are considered pretty good runners, 37.18 hours of driving per week and 49.43 hours per week on driving. They're not getting anywhere close to 70. So in my case, where I use the 34-hour restart for a different purpose, and again, to give flexibility in a schedule, in my average length of haul for our fleet, 650 miles. We're considered a long-haul, irregular route carrier. We're a steel hauler. We're a flatbed carrier. I use that to illustrate we have the facts to the hundredth, of a minute. So EOBRs give you the correct data so you can manage it from an operational standpoint, from a safety management standpoint, from a pricing standpoint, how you utilize the equipment. Now, the part that makes it obviously the most important is that it gives law enforcement the ability to quickly, with technology, aggregate data with the help of, which I'm a tremendous advocate for, CSA, a combination of those tools that we, in fact, can focus the resources on those carriers and drivers who have habitual driver hours of service problems or from a fatigue management standpoint. So, yes, the system can be beat. These guys have a lot of time on their hands to figure out how to, this is interesting. These guys are always, and gals, are trying to find ways of creating flexibility for themselves so they can work harder. They're not trying to go out and hurt people, but so we have to constrain them in many cases with these regulations, and that's understood, but they have to be right-sized, if you will. But EOBRs, again, are the tool. Again, I don't really believe that there's much hope for any real progress unless we can get an EOBR mandate in short order, because it is the foundation that will ensure that people will do the right thing, or they will not be. So many people think that trucking or owning a truck line is an entitlement. It's not. It's a privilege, and we need to look at it that way.
Thank you, Mr. Williams. I want to direct my attention now to Administrator Ferro. You've heard what Mr. Williams has to say about it. You know the data on it. We authorized EOBRs in MAP 21, and I don't think you're going to hit your October 1st deadline for the rulemaking. You want to elaborate on that and kind of let us know where you're at with respect to the timeline for implementation?
Yeah, let me just reinforce the electronic logging device rule, which had been EOBR's ELD, is a very important rule. And frankly, we cannot get it done fast enough. I felt very strongly about this one for a very long time. You may be familiar with the court history on it, and we need to be sure not only do we get every piece right, it's got to be completely defensible, but we also incorporate the elements of MAP 21. So the supplemental notice of proposed rulemaking, because we're building on a NPRM we had issued in 2011, will be on the street in the fall of this year. You're absolutely right. It won't be the final rule. It will be the notice of proposed rulemaking, and it will incorporate 4 very important pieces, one of which is the broad mandate across the industry that uses record of duty status to monitor hours of service to ultimately improve compliance. The second component, very important, and you heard Major Savage speak to it, is the supporting documents piece, ensuring that there's clarity and efficiency in supporting document retention requirements and accessibility requirements. If you're using technology, you shouldn't have to keep as many papers, but certainly law enforcement ultimately needs to be able to use the tool. There's a component of the electronic logging rule that must prohibit the use of that technology to harass drivers. So that's the third major component in that rule. And then the fourth major component, sort of underlying all of it, is the technical spec. So it's a broad open technology, reflects kind of all the advances that have been made so that it's affordable, it's accurate, it's not, it's hamper-proof or tamper-proof, tamper-proof. So those are the 4 components. And again, I couldn't agree with you more. We need to get it out there. Yeah.
Thank you. Yield back.
Thank you. Mr. Walz.
Well, thank you, Mr. Chairman, and the ranking member for holding this. Thank all of you for being here. I, for one, am grateful for all of you are a part of this. And I know my family's out on the highway. Our economic well-being is dependent on that, and trying to strike that proper balance. We don't oftentimes get an issue that I do believe the core issue here is safety, and then making sure people have the ability to be profitable in moving products. We have to be able to strike that balance. So as I'm listening here, I don't think there's a lot of space between there. There are a couple things, though, and I think Mr. Crawford started to hit on this that I'm trying to get at. This is, how do we focus on the bad actors without doing damage in a blanket report? And I think, Mr. Williams, you were kind of getting at that there's certainly, I have to tell you that the one thing I find is, and maybe it's just the nature of this business, but when I go to visit my small carriers, safety is the air they breathe. I mean, I get that impression when I go in there that that's the air they breathe. They want to get right. When I talk to my state patrol, it's about safety and moving commerce and understanding and driving that. So we're really similar in this. Who are the bad actors in this? How are these folks getting around it, or how does that happen? Is the margin so tight that it just creates a situation? Or do you think, Mr. Williams, I think you hit on something really interesting that I think there's true in that it might not be bad intent a lot of times. It's folks that just are really trying to work hard, and it's one of those jobs, and I know this, like, military-wise, forcing people to sleep in the military was really, really hard because they're driven, they want to get the job done, but if they don't sleep, they degraded our capacity. So I don't know. Mr. Williams, I'm looking maybe to you and Mr. Stocklin first on the end, see where, what do you think? How do we weed out those bad actors without putting you in a bind for doing the right thing?
Well, again, going back into the context of the challenge is going to get much greater. I'm really glad that we're doing the things that we are. Again, I believe that CSA is doing the right thing. It's identifying who those bad actors are. We're eliminating, once identified in the past, a bad driver, for example, could leave a bad carrier that had been characterized as such and show up at another carrier and taint his record. We're closing all these little loopholes, if you will, and the administrator's done a really good job of trying to accelerate that process, because there's an awful lot of people in the shipping community. I have customers that think that she and her administration has been making idle threats that their world's going to change, and that, in fact, there are no teeth in this. And I'm waiting for us there be more. There is evidence, there is actions being taken against bad carriers and bad operators. It goes on. It just hasn't been maybe as visible as I would like to see it. I'm a firm believer that it needs to be tough to get into this industry, and it needs to be tough to stay in this industry, and that those of us that are here then can afford to invest in the solutions from driver pay, driver benefits, proper work schedules, and all such to make the job a better job. So it's an economic issue, yes, but again, we can't get there without the help of the regulators with leveraging the technology, and again, embracing CSA. I think the framework is there, and the clock is running. I just think that I just wish we could get there a little quicker.
Major Savage, if I could ask you on this, your folks see this, and I know I was pleased to hear the chairman of the full committee talk about science a lot on this, is that you mentioned there's folks trying to game the system or whatever. Can you feel that there's I don't know how to frame this other than, are there carriers that just have that air they breathe culture of safety, and are there others just trying to get around it? How do you, because you're just identifying the bad actors as you stop them, no matter where they came from. What's your take on this?
Mr. Chair. Mr. Congressman, that's an excellent question. I'm very glad you asked it, because in our business, our goal is to remove the unsafe drivers and carriers from the road.
Right.
That's my ultimate goal. I've been on the scene of terrible crashes, and I don't want to continue to go on those scenes. So I want to remove those drivers from the road, whether they be in cars or trucks. It's irrelevant to me. I want to make the road safer. That's our goal. So one way to do that, and probably the most effective way to do that, given the data that we have, make sure that that data is the highest quality possible, it's accurate, it's uniform, and then use that data to prioritize and identify those carriers that should not be on our roads, and target those carriers and remove them from our roads. And if we take and we use the data, we're data-driven to begin with. If we use the data, we use the performance data to identify those carriers and spend the majority of our time focusing on those folks, removing them from the highways, those carriers that, like you say, that are compliant, and the great majority of them are, those carriers that are compliant, allow them to continue to operate as they should.
When we come back around, I want to get at this issue, Mr. Chairman, on, I think that's exactly what Mr. Williams, Mr. Stocklin want without a doubt. The issue I have is the ability for them to be able to know who that bad actor is before they get them. At times, I do feel like at times they're forced to almost take this person. There's a shortage. This is a tough business. It turns over. And you end up getting someone, you don't have a background that they've been convicted of this or whatever. That does seem inherently unfair and wrong, and they don't have the resources to weed them all out at this point. So when that comes back, I'll ask. Thank you, Chairman.
Thank you, Mr. Walz. Mr. Rice.
Thank you, Mr. Chairman, and thank you to the witnesses for being here today. It's certainly an educational experience for me. Mr. Stocklin, I want to hear from you. I want to hear about what you think about these onboard recorders. How much do they cost? How effective are they? You think they're something that's going to really bring down the accidents? I want to hear your opinion, sir.
Well, I don't really know anything about the onboard recorders, and probably if they force me to do it, I'll just quit. Bottom line. They may work in large companies because they can keep track, and I understand having leasers on where you get these bad guys on there that cause you nothing but problems. So I'm kind of looking at it from a different perspective, because I'm one truck, one guy. I only have to worry about me, and I do good safety. I have a good safety record, and my whole goal is to be safe while I'm driving all the time. And I do over-dimensional, over height, over width, all the time. That's what I do. I think the bad drivers, and I've trained quite a few guys who've got it in them and watch them leave, not knowledgeable what it costs to run a truck, just trying to make the money, running too cheap, because it's all about the money. They don't take care of the truck because they don't have any money, because they're running too cheap. So in other words, you have to make enough money to maintain your truck, make your house payment, and all those things you need to do. Now, looking at this as a one-truck guy, and it's hard to do. It's not easy. I've been doing it for years. It's all about the rate. It's all about the money with trucks going down the road. And some guys, they run for $1.50 a mile and think they're making money, and they're not.
All right. So you see and you acknowledge that there are bad actors out there.
Absolutely.
People who will falsify writing down records and so on.
Oh, yeah, yeah. It was just a few weeks ago.
So how do you attack that if you don't have these onboard recorders?
I don't know. For me, I don't run illegal anyhow. I guess for those guys, that's what you need. Maybe you should look at it, that their safety record is so far, maybe you should put that recorder in their truck. Just like you do when guys get DUIs, they have to blow in the little thing. You see my point. Let the good guys, the guys who do a good job, take care of that, because kind of punishing her, because I don't know what the cost is. Could be $4,000, I don't know. But, it's all about how much more it costs you to run, just like these 34-hour restart. I run from coast to coast. I may go Midwest, not quite all the way to the coast. It takes me, by the time I load, to get to the Midwest, and I have curfews, I have maybe pilot cars, daylight hours, all of this. It may take me five and a half total days to do that in one direction. So then I sit there, and I have to wait that 168 hours out before I can do my restart, which I'm sitting there for nothing. And it's actually more tiring to sit there for extra days. You're not accomplishing anything.
All right, if you could change one aspect of this new rule,
I would leave
one thing, what would it be?
I would leave the 34-hour restart exactly the way it is. I never run over my hours. I have plenty of rest. And a lot of the aspect is the time of the week of when you haul the freight. I try to haul freight in the right time of the week where I'm not in the traffic. I try to stay out of the traffic as much as I can. Just like going through Seattle.
If this 34-hour rule stayed the way it is, you would be happy with it?
Oh, yeah, absolutely.
I'm running out of time. I want to ask a question, Mr. Hinkle. Mr. Hinkle, average drive time for your drivers from point A to point B. What's your average drive time?
Probably 15 to 20 minutes to 30 minutes, somewhere in that range.
So if they're driving 30-minute increments and they're waiting 15 or 20 minutes or up to an hour or more, right?
It could be. It's driving, in our operations, driving time never really comes into play. It's the on-duty time. You know, in a common 14-hour day, 5 hours max.
So you think a 30-hour mandatory break would decrease driving fatigue if they're only driving 15 or 20 minutes?
No, I mean, that's our whole thing. I mean, having to mandate they take a 30-minute break off, that's not going to decrease their fatigue level.
One-size-fits-all requirements don't really work.
Absolutely not.
Thank you, sir.
Ms. Napolitano.
Thank you, Mr. Chairman, and I'm sorry I've been in and out, so I may be asking questions that have already been addressed. But I'm wondering why the rulings of the U.S. Court of Appeals continue to be defied when it comes to revising the hours of service ruling. Anybody?
The decision was made in 2004 after the court ruled that they would make one minor change, and the Federal Motor Carrier Safety Administration would just reissue the rule, because that's what they wanted. And I don't know that they thought that they're going to be sued again. I was very much involved in that litigation. And we decided to sue again because they had essentially ignored the Court of Appeals. And the Court of Appeals then ruled again, and they did the same thing.
Twice?
Twice. When the new administration came in 2008, 2009, they asked if we would hold off on the litigation until they could develop a new rule. And so we agreed to do that, and they developed a new rule, which we consider to be de minimis improvement in safety. And so we sued again. And that is the case that is now pending. It was argued in March.
Is there any scientific data there to support that an increase to 11 hours actually improves safety for a truck driver? And any studies that verify driver performance increases after 10 hours of driving?
No, just the opposite. The scientific evidence shows that after 8 hours of driving, which is what everyone else in America works, truck driver performance degrades. And by the 10th and 11th hour, it's really bad. And really, I know that the industry will go crazy when I say this, but really what should happen is that drivers should be paid by the hour. And they should be paid overtime when they work overtime, and over 8 hours a day. And so the 10-hour rule, which was in effect for 70 years, was something that we thought ought to be reduced, and instead it was increased.
Thank you. The Highway Patrol in California has given me some information, and they're telling me that there are many unemployed, but why can't the trucking industry hire and retain drivers? They say there's 20,000 to 25,000 short. And you're right, maybe paying them hourly might change the ability for them to be able to be a little safer.
Well, I think that the life of a truck driver who works 14 hours a day, when everyone else in America works 8, That's a pretty miserable existence, and a lot of drivers quit the business because it is a really, really tough job. And that's one of the reasons that they have a shortage. And if you look at what they're paid in relationship to the amount of time that they work, it's a pretty low pay, and so they get better jobs.
Median, I'm being informed, is almost $38,000. If they work 70 hours, it works out to $11.15 an hour.
That's right. It's a very small amount of pay. It's almost, well, it's above minimum wage, but not a whole lot.
Then the other area that concerns me is the health risk and the life expectancy associated with truckers. And I've known several of them, and it's the nature of the job, whether it's the diesel exhaust, the body vibration, the excessive noise, the constant shift changes, the roadway dangers. They are reduced to 61 years, 16 years less than average. And the high risk would be in personal injury, high blood pressure, heart attacks, diabetes, obesity, cancer, liver, kidney, bowel, and bladder issues, sleep abnormalities, and hearing loss. Is that worth it?
Well, a lot of drivers don't think it is. And in addition, as I mentioned in my testimony, it's one of the more dangerous occupations in America. The likelihood of being killed is higher than in many, many other occupations. So in addition to all those other health risks.
Thank you. And anybody care to respond to any of these, please?
Well, you're asking about health issues?
Yes.
Number one, in the truck stops, they don't have any good food. Number one. I'm telling you.
I'm sorry.
They don't have any good food.
Oh.
And you may laugh at that, but that's a fact. And these guys sit in there for 2 or 3, 4 days waiting to get reloaded, like it would end up being with a restart, more time sitting in the truck stop, and all they have is junk. And they're way overweight, you know.
And no exercise.
I mean, and I'm 65 years old. So 61, I mean, I've been doing this for years. But it's the industry, it's the truck stops, it's the whole thing.
So it's a lot of other...
and it does pay those guys cheap. It is cheap pay to them. That's why you have a hard time getting them.
Thank you, Mr. Chair. I have questions for the record.
Mr. Chairman? Mr. Chairman?
Where?
Could I respond to that very briefly?
Very briefly.
I think that there is some research, it was data from trucks involved in fatal accidents, a study done in 2007, where in fact the 11th hour of driving was in fact the safest hour of the day. There was only 1% of the accidents that occurred in the 11th hour of driving compared to all the others that were measured. And then secondly, in regards to driver pay, our starting driver will make $50,000 a year and it goes up. There's an awful lot of truck driving jobs in this country that pay $100,000. And also there's an awful lot of the major truck stop people that are providing health centers now and better options for food. But I can tell you where the drivers will stand and eat if given the chance. So you can lead a horse to water, but you can't make him drink.
Mr. Chairman, could I just, Mr.
No,
Chairman,
we'll
Mr. Chairman, could I just comment?
No.
Could I just comment for 1 second on that? I just want to say that the 11th hour of driving is lower deaths because, in that particular study, because there are fewer drivers driving the 11th hour. So you have to look at the data. That's not scientific. Thank you.
Mr. Ribble.
Thank you, Mr. Chairman. Thank you to the panel for being here. I'd like to start with Mr. Williams. Mr. Williams, I spent 35 years as a commercial roofing contractor before coming here to Congress. I'm actually thinking I need a 30-minute break because I'm getting fatigued being here. But my question is this. It was my observation that if we could get a new employee beyond 6 months without an accident, we typically had a pretty safe employee. And a lot of stuff happened in the early times, and it wasn't whether they worked long days or short days. It was the amount of safety training they had and experience. Could you talk a little bit about that? And also, would you tell me whether you believe that this rule is going to affect the ability for you to recruit new drivers to this trade?
Thank you, and those are really great questions. Historically, we were a company that hired only experienced people. Last year, we actually hired 1,069 individuals, 922 of which we trained, 86%. at a cost of close to $8 million. That's just because of the demographics of our workforce have changed dramatically. We have an awful lot of people that are leaving the industry because of age. This is in the LTL industry, the unionized LTL industry. Walmart, for example, has a lot of the top line jobs. There's an awful lot of the people that are exiting the industry because it's demographics. So we are compelled, if we're going to seat people in our trucks, we have to reach out and train to do that. The important thing is that that training be done correctly, and we're using driver simulators to simulate situations, hands-on training. It goes on for up to 10 weeks, depending on the person's level of experience. There's a tremendous cost associated with it. But the good news is that it works. We're actually putting up some of the best safety numbers in the industry as a carrier, using people that have tremendously less experience than they previously had. So a training requirement and the ability to train properly is in the world that we're living in, and the challenges we're going to face with changing demographics going forward is going to be really, really important.
Would it be more important than hours of service changes?
I don't think that I'm capable of distinguishing that. I truly believe in getting the hours of service right. I think that there are limits to that as to how much a person needs to work, and I agree with that completely. I do believe that the losing the 34-hour restart is going to lessen our drivers' home time, which in fact is going to make it more difficult for us to keep a driver working for us. Most of our drivers are home every weekend, and this will prevent that from happening, and that will increase turnover, which we have an industry-leading turnover rate of 59% last year, which is, to me, pathetic, but it's almost half of what the balance of the industry is. So as the economy heats up, you're going to see driver turnover move up because people move around from company to company trying to find a better job, and that's not good for anyone necessarily. But the 34-hour restart, it will probably be problematic for that from a retention standpoint, not so much for attracting people. And I'd also maybe use this opportunity to say that the 30-minute break, and the part that we really want to point out is that in order for us to get the 30-minute break, it'll probably take us an hour in order to achieve that. These trucks have to get off the road, go through an intersection, get into a truck stop, take the 30-minute break, and then start that process over again. So I'm not saying that the 30-minute break is wrong. I'm just saying it's really the impact on the industry isn't 30 minutes, it's more of an hour. Just wanted to point that out.
Mr. Stocklin, first of all, I want to thank you for coming. I want to thank you for your service in Vietnam. And I know you've come all the way from Washington State, and you're an independent. So what would you be doing today if you weren't here?
Trucking.
I apologize that you feel. I apologize that
my wife would make sure I would be trucking. I guarantee
appreciate that. And I apologize that you feel that what's going on here is so important and affecting your business that you had to come from your business to tell us these things. In your testimony, you said if we get in an accident, regardless of fault, it is our truck that's in the shop. We have to pay the out-of-pocket to get it fixed. We will not be out there hauling freight and earning money until it's fixed. The downtime alone can mean bankruptcy for owner-operators. And then you go on to say a little bit later regarding flexibility. Flexibility means giving me, the professional truck driver, the ability to drive or take rest when I am best able to get the rest I need and when I am best positioned to operate my truck safely and efficiently. Do you believe that during the rule-making process that the administration took into consideration those thoughts?
No, they don't see it like I do at all. I mean, in order to see what really goes on, you have to get in the truck and go with me for a week. Then you'll know, because, like I say, if I leave Seattle and I have an over-dimensional load on, and I go to the East Coast or Midwest, wherever I go, and I take like 5.5 days to do the whole turn, depending on the situation, depending on weather, depending on whether I have a pilot cars, depending if I'm out of route, and all of the above. When I get there and I unload and I have to restart my clock, which I take my 34 now, and I restart, I got plenty of time to do any maintenance I need to do on the truck, get it, whatever I need to do. Usually end up waxing it because I'm so bored. And I load my load, and I try to load it in a certain time of the week where the traffic's the best, because a lot of cities I'm in curfew, I can't go through, so I have to do certain times. That's where the half hour, like Mr. Williams was saying, a half hour isn't just pull over and park for a half hour. Now you got to get off a safe place to park, so it takes you a lot longer. So you could have an hour more in it. But this restart they want to do, it just extends that time for me to do it. It's going to cost me $30,000 to $40,000 this year for 1 year to do this, because I'll lose that money, which means less revenue to maintain the truck and do these different things.
Thanks again for being here and for your testimony today. And with that, Mr. Chairman, I yield back.
Thank you. Let's see, Mr. Carson.
Thank you, Mr. Chairman. This is for Administrator Ferro. Map 21 includes language requiring the DOT to issue final regulations establishing minimum entry-level truck driving requirements, which would include both classroom and behind-the-wheel training for first-time commercial driver's licenses. Can you talk a bit about the importance of behind-the-wheel training, if you will? From what I understand, it wasn't even mandatory prior to MAP 21 language. So I'd like to know whether you agree that a truck driver should spend time behind the wheel of a truck before obtaining a CDL, because I've seen numerous reports of driver training schools offering programs that advertise that drivers can obtain a commercial driver's license in as little as 24 hours or a shorter period of time. So will the upcoming rulemaking include a core curriculum that every driver training school must instruct before drivers can graduate?
Thank you, Congressman. Yes, I agree that some level of behind-the-wheel training must be part of any sort of entry-level driver training requirement. The agency has worked on this issue for a number of years and has been challenged to identify the benefits, the safety benefits of training in the longer-term career of a driver. What's so challenging about this rule is that it's common sense. Everybody agrees. This is a very complex task. Drivers should be trained. They should be well trained. It should be including behind-the-wheel training. And the challenge has been to find the research that documents that there's a cost-benefit gain, a net benefit when you do this rule. We have undertaken that research. That research is underway. The rule is very important on our agenda. And we have begun our working groups. We've done several listening sessions. We had a great listening session at the Mid-America Truck Show in March and heard from lots of drivers about just the points you made and what should the credentials of the trainer actually be. Today, some trainers have only had 3 months of driving, and they're popped into a truck to train another driver. Drivers are saying they should have at least 3 to 5 years of training. I suspect Mr. Williams would agree based on the investment he's made in training. And so, yes, we agree, I agree, and we're pressing forward. But it's, again, and it is absolutely part of MAP 21, which is a positive development. Yeah.
Thank you. Mr. Chairman, I yield back.
Mr. Williams.
Thank you very much. I appreciate all of you being here. I, too, want to acknowledge the families that have lost loved ones. God bless you, families. Also, I want to, first of all, say I'm from the private sector. I've owned a business, still own a business for 42 years, car and truck dealerships, transportation. And I want to thank Mr. Williams and Mr. Stocklin and Mr. Hinkle for your investment in the free enterprise system and what you do. I appreciate that greatly. I guess what I would ask you is, what can we do as Congress to help improve your industry and your safety, at the same time making sure that we help your business so you're able to do business and not be regulated out of business? You know, I know that I'm one of those. I believe that you know your business better than the Federal Government, and there's no question that you want to be safe, and safety is probably the most paramount thing that you have. So I'd just like to hear, you know, what can we do? I mean, this is your chance to tell us. I'm a business guy, and I would just like to say one thing before you answer to Ms. Claybrook. In the private sector, many, many more people work more than 8 hours a day. I must tell you that. 8 hours is not the standard, and I have found that only to be, frankly, since I've been up here in the Federal Government. But with that being said, you might start off, Mr. Williams, and let us know how we can help your industry.
I think there's a proper amount of regulation. I believe I've done this. I started the company 33 years ago. We're recognized as a leader in safety. I'm very proud of our people. We do a really good job with the challenges that we face. But I've also seen the good, the bad, and the ugly in trucking. And I can say that left without any regulatory oversight, the trucking industry, like many other industries, won't be what we need it to be to meet the fundamental challenges that we're going to face in the years ahead with congestion and growth of the economy and all the above. So I think it's important that we encourage and continue to evolve in the proper regulatory oversight. And again, I give credit to Ms. Ferro and her group for the work that they've done on CSA and their willingness to continually try to make things better that maybe needed additional tweaking. You know, again, I think it's important that we understand the necessity of good regulations to ensure that the constraints are placed upon the people that need to have constraints placed upon them. So I like, by the name of my company, Maverick, it kind of implies I don't really like to be hemmed in too much. I'm not which came first, the name or you know, whatever, but the fact is that there are constraints that must be placed upon us in order for us to have the positive outcome that we need to have. So I'd say just continually committed to listening and willingness to modify and change and improve, because we all believe in continuous improvement or we really won't be around here much longer anyway.
Thank you. Mr. Stocklin?
Yes. I think there's a few things you can you can do. I think you need to make sure when they're doing the training on some of these people, because I've seen a lot of trucks that come in the truck stops. They can't even back into a parking place or back out of one, that I've actually had to do it for them. And I asked them, how long you been driving? They said, oh, like 2 months. And where did they get their driver's training? I don't have a clue. But I think, yeah, some regulation is fine, but too much is going to put the little guy out of business because you just can't absorb the cost of it. That's just my opinion, you know, from what I can see.
Mr. Hinkle?
Well, in the ready-mix concrete industry, just like Mr. Rice brought out, the regulations is not a one-size-fits-all. You know, the short haul or the ready-mix industry is a totally different animal when it comes to looking at hours of service, on-duty time, driving time. So, you know, we just asked we need to look at that specific industry, just like we have exemptions for agriculture, oil field. You know, the ready-mix industry is different, and we'd like to be looked at and see if we can adjust the regulations to help us.
Thank you, Mr. Chairman. I yield back.
Thank you. Mr. Perry.
Thank you, Mr. Chairman. I'd like to just start out by acknowledging the families that are here for their loved ones, and I assure you that if the same thing had happened to my family, I imagine I'd be sitting right where you are. That having been said, I got to say that I'm concerned that maybe we're getting the cart before the horse here, and in deference and in honor of the folks that have lost their lives in your family, I want to make sure we're getting to the point. And I got to be truthful, I'm not sure we are. You know, as I read this, there's a restart field study that I guess is required, and I don't know if that's part of or if it's something separate than the real world study. So, Ms. Ferro, if you could let me know if those are the same thing or if they're two separate things, first of all.
The study that supported the development of the rule and the restricted use of the restart was a laboratory study. With the theory that if an individual has a challenge sleeping with recovery sleep after this kind of a grueling schedule with the current restart under ideal conditions, then imagine what it'll be like with someone who's not as healthy in the operating environment.
But are there two studies or is it one study?
So that's the first study. The second study is mandated under MAP 21, right, and it's the field study that we launched as soon as MAP 21 was enacted. The first driver was entered into the actual field test itself.
But it's not complete yet.
It's underway now. That's
so,
correct.
But the first one, the restart, is that one complete?
The lab study is complete, and that's very much a part of what's supporting this rule in the context of the need for recovery.
But the real-world study isn't complete yet.
That's
and,
correct.
And the first one is a lab study.
Yeah, we'll see the results of
And the rule goes into effect July 1st.
That's correct.
So why aren't we getting all the information before we enact? It seems to me you have incomplete information. I mean, I hear some of the episodic data here, but, and let me ask you another question, because that's somewhat rhetorical. But, and with all due respect to the folks in the agency and so on and so forth, what is their experience? Who are the people that are making this rule, that are writing the rule? I hear you receiving testimony and so on and so forth. Have they driven a cement truck? Have they driven 80,000 pounds across country? What is their experience level?
We have plenty of employees who have prior industry experience. They either are CDL holders themselves, in some cases CDL holders, prior safety managers. A specific member of this team was a dispatch and safety manager in industry. So yes, is that the basis on which we hired them? No, but they bring all of that perspective to the table. The hours of service rule that takes effect on July 1 is based on years of peer review research, more current research into fatigue and its impact on workplace safety, and specifically with regard to the 34-hour restart, a study to examine how that restart used under today's rule, where a driver could actually run up to 82 hours in a week, how that contributes to chronic fatigue week after week after week. The majority of the industry doesn't maximize the use of that 34-hour restart. In fact, they don't even have to use it. It's a voluntary restart provision. The vast majority of the industry doesn't run the currently mandated limits of 60 hours in 7 days or 70 hours in 8 days. Those limits existed prior to 2003, they existed during the 2003 and subsequent rule, and they exist under this current rule. The only difference that happened between 2003 and 2013, is that 60 and 70-hour work week could be restarted sooner with the use of that 34-hour restart. So again, it's lab-based in terms of specific to the restart, but the science behind fatigue, the impact of chronic fatigue on a driver's health, the impact on fatigue on a driver's safety are absolutely solid research.
I mean, I think from my background, I'm fairly familiar, but I can tell you from personal experience that, you know, I can leave home to come here, and I could pull over within 15 minutes and take a nap on some days because I'm tired before I leave. And I can also tell you, you know, overseas in a combat zone, I went days without sleeping and still operated safely and operated complex machinery safely. And I just feel like we're throwing this rule out, which does not support Mr. Hinkle's business at all. I've also been a contractor that received plenty of loads of concrete where the guy on the truck, you know, unless he's pulling the lever, he's just standing there waiting for me to get done with my work, and he's getting plenty of rest while I'm, you know, toughing it out. And I feel like this one-size-all approach is not in line with the practical reality of what's happening in the industry. And with all the input that you've gotten, it seems like these folks from industry, this gentleman here represents 40% of trucking, independent truckers, they disagree with your findings completely. And so if you've gotten all the input, it seems to me like without the results of this final study, that you're putting the cart before the horse in some respect and issuing the rule. And once these rules get issued, they get a life of their own. And that's one of the problems people have with the Federal Government is that it goes unbridled and there's no accountability and there's no turning back. It only gets worse from here. It does not get her. Thank you, Mr. Chairman. I yield back.
Thank you. Mr. Hanna.
Thank you. I want to concur with Mr. Perry. The divergence between the practical and the real world and the theoretical world, to me, as I listen to this conversation from all of you, could not be greater. I've heard accusations, Ms. Ferro, that you don't use science, that your opinions are subjective, they sound somewhat value-based, that in fact there's some data mining, that long-haul trucking for the 8 hours, it may be applicable to ask someone to rest for half an hour, but for the concrete, the asphalt, the aggregate delivery system, it has no bearing, and yet we're perfectly comfortable costing these people tens of, maybe hundreds of millions of dollars over time, when it would be a simple fact you could just exclude them from the process, local deliveries like that. You've heard Mr. Stocklin accuse the CSA of being impractical. You've heard Mr. Hinkle say it's impractical. What these people are saying is they want to be safe. They want to run a tight, competent business. Their insurance companies, believe me, have more of a hammer over their head than you ever will. We've heard the sheriff from, rather the state policeman, say that none of this may help or may not help without a way to monitor these people on a regular and scientific basis through these truck-mounted devices, GPS devices, et cetera. All of this makes me feel as though we're creating a whole host of rules, confining a whole lot of people to do less, make less, cost the public more, and without doing the one thing that I thought we were charged to do, and that is to do a study before we write the rule. Aren't you concerned, Ms. Ferro, that applying all of this, and arguably it isn't all this way, in fact, before applying these rules before the study is complete actually undermines the credibility of you and your agency?
There is a significant amount of research and study behind the rule that is taking effect July 1. Let me be very clear about that. It's substantial. It's a full body of peer-reviewed research and analysis. It is in the rule that was published. We incorporated it into our NPRM. When we issued the NPRM, we held an enormous number, a really unprecedented number of listening sessions.
Their opinions count?
Their opinions count a great deal.
Well, where do they count? You said you've listened to hearings. Apparently, they don't count, because Mr. Hinkle's sitting here telling you none of this is going to not only make things safer, but not to paraphrase you, but it may make things worse. It may make the public pay more. That in his case, where asphalt, and I assume also asphalt and concrete and other local deliveries are completely irrelevant to what you're trying to talk about.
No,
and have you ever done a study about concrete specifically or asphalt specifically?
So two things. The relevance of what I'm doing is all about safety, saving lives. The fact that the agency has been tremendously transparent and responsive to a host of concerns that were raised. That's why we went out and did listening sessions across the country. We heard a great deal of input. This rule started out with the option of a 10 to 11-hour drive time. We weren't sure. We had our finger on 10. Our research, our analysis, our listening sessions all led us to conclude the 11-hour driving time is the right time, and in fact, it cut the cost of the rule by $500 million.
Have you studied Mr. Hinkle's business?
Mr. Hinkle's business has the opportunity to take advantage of a 24-hour restart. They already have an exception in law that provides him the flexibility that he wants.
Mr. Hinkle, would you like to respond to that?
Well, it's the 30-minute break that we're concerned with. 30 minutes consecutive is going to be a problem for our industry, where they get, several breaks shorter than that, I think are sufficient to keep their fatigue level down.
Yeah.
All right. Yeah, so the 30-minute break is a body of scientific research that goes well outside of the trucking industry, any sort of workplace science. But back to your original point, the concept and the challenge of this one-size-fits-all, I think that's at the heart of much of what you've heard. I understand that. This is a very big industry. It's a very diverse industry. It's 500,000 companies that we regulate across the country, some private, some for hire, some hauling steel, some operating locally within a 20-mile radius doing concrete. The agency, long before I was here, tried about 15, 20 years ago to do a rule that segmented out the sectors, that recognized that short haul had a different operating environment, construction had a different operating environment, oil fields. And that was roundly panned. That thing didn't even see the light of day beyond the NPRM. I'm not saying that that shouldn't be examined again. And my sense is with the use of electronic logging devices, with improved registration requirements, we'll be able to look again at that concept of segmentation. But today, it's absolutely true. The best structure we can use is a rule that constrains the margins of abuse while still sustaining the vast majority of today's operation in a very healthy and productive way.
Thank you, ma'am. My time's expired.
Mr. Duncan.
Well, thank you very much, Mr. Chairman. And I had to come late to this hearing because of another hearing. I did I did hear Mr. Williams, part of his testimony, in which he said that these new rules are just not supported by the facts or the evidence. And I've been in and out, and it seems to me that the gist of the testimony of all the witnesses who work in this field seems to be that they just need and want more flexibility. And I actually can understand that. You know, these truck drivers are human beings. They're not computers or machines. They go to, people need different amounts of rest. They need different, they have different body clocks and so forth. And it seems that to some people that these new regulations would keep drivers from splitting up their break time and really adjusting in the way that they need to. But Administrator Ferro, is it correct that these new rules are in litigation at this time? They're in court right now?
That's correct. Oral arguments were heard March 15th of this year.
Well, wouldn't it have been better to have given the courts the time to determine if these regulations, I mean, what happens if we put these in effect and then the court turns around and throws them all out? I mean,
in my view, it is not worth the trade-off of losing the safety benefits today while we're waiting for the court decision. And I say that for two reasons. One, the safety benefits of improved driver rest for those operating at the margins and their health are significant. Second, I have very high confidence that the rule is strong. It will be upheld by the court. The last time there was a court challenge, I think it took almost a year for the court. Courts has a lot on their plate, a year for a decision. We could have conceivably had to delay this rule a year or more. It was put into effect, it was finalized almost a year and a half ago. So there's been lots of time for folks to prepare.
was Mr. Williams incorrect when he said that these deaths and accidents were going down significantly over these last few years?
He was correct. I used some of the same data in my opening remarks. He's absolutely correct, and that's very positive news, and it doesn't stop us from driving towards getting to zero.
Let me ask Mr. Hinkle and Mr. Stocklin, Mr. Williams, you know, these federal agencies come up with these comment periods to make themselves feel like they're getting some public input, but they really don't. They get comments from the professionals and the lobbyists and so forth, but from the ordinary people, they hear very little. Have any of you, have your drivers been polled, or has there been any significant effort? Have some of these federal officials come to your locations to interview your drivers, or have you heard about that happening any place? Mr. Williams, has that happened at your business, or Mr. Stocklin, has that happened to you or drivers that you know? Or Mr.
No,
Hinkle?
it hasn't happened to me at all. Nobody's asked me any opinions of what, you know, how it should be. I just want to say one thing, that, you know, part of this 34 restart and the money that you would lose, and they're all concerned about safety. Well, part of safety is maintaining your equipment. And if it costs you money and you lose that money to maintain your equipment, isn't that part of safety? You know, I mean, you've got to do brakes, you've got to do tires, and all of these above things, you know.
Mr. Williams, how many drivers do you have?
About 1,450. And I would have to say that the listening sessions were very publicly acknowledged. I think CVSA would probably agree with that as well, that they did a really good job on their listening sessions, and I have many drivers of ours that did participate in those. And then, of course, in the radio blitz and everything that they did as well.
Do your drivers support these new rules?
Well, no, our drivers don't like the 34-hour restart, anticipated changes in the 34-hour restart. They don't particularly like having to take the 30-minute break. But But, so no, I mean, it's, yeah, I mean, I've heard their voices, and I've passed those along, and they've spoken individually at a lot of these different listening sessions.
Mr. Hinkle?
Well, I can tell you, at Chandler Concrete, we spent the last 3 to 4 weeks going through, bringing all our drivers in, going through all the changes that are coming up, because we're going to comply one way or the other, whether we agree or not. Do they like it? No. Just like I said, the 30-minute break is the biggest issue with us, and basically they're going to lose 30 minutes of pay a day.
All right. Thank you very much.
Mr. Mullen.
Thank you, and thank you for this opportunity. Mr. Williams, Mr. Stockton, Mr. Hinkle, I kind of feel what you guys are talking about. I've said this over and over again, that our biggest threat anymore to our companies are federal government, trying to comply and still be profitable. Mr. Stockton, I found it very interesting that you said, I'll just quit. It's not because of your safety record. It's not from the fact that you can't manage your company and make a profit. It's the fact that it's going to eventually get not worth it, where you can't invest in it. Because, see, there's a fine line between 7% profit margin and being able to reinvest in your company, and 6% profit margin when you just try to maintain your equipment. And when you just try to maintain any company, you begin to die. And that's the whole reason why I sit in front of you today, because we also have over 80 trucks on the road. And what Ms. Ferro and some other groups are trying to push, just simply, it doesn't add up with the industry. If you look at the industry since 1975, 77% fatality, we have reduced fatality rates by 77%. There's something to be said about that. And I commend the industry for the work that you guys have done, constantly working on trying to improve the safety records of our own companies. I tell everybody it's our best interest. None of us want to have an accident. It's our companies, and it's the lives of those that are around us too. Ms. Ferro, I got a quick question, and I'm going to kind of switch gears. But as you're probably aware, I introduced a bill, H.R. 1097, that would ensure the on-duty times not include waiting times in natural gas and oil sites for operators of commercial vehicles transporting supplies and equipment. This is an exemption that had been in place for over 50 years, and for some reason it was taken away in 2012. Can you explain why that was taken away?
Congressman, thank you for that question. The exception policy that applies for oil field operators was not taken away. There are two provisions. One allows oil field operators and servicing organizations to...
Well, ma'am, it actually has been taken away, because we're not allowed, wait time isn't included anymore when we're sitting at a drill site. So what do you mean it has been taken away?
So the first provision uses a 24-hour restart. They take full advantage of it, not unlike the concrete industry. The second exception that you're speaking of, that was put into place by the Interstate Commerce Commission 50 years ago, provides an exception to on-duty
I know what the
driving.
exception is.
Yeah,
what I'm saying
yeah.
is, why is that exception not provided anymore? Why was it taken away in 2012, increasing in the number of trucks on drill sites now, increasing the cost to deliver those supplies have increased now, when essentially when they're waiting at a drill site, it's like a country truck stop. They can go in, get coffee, watch TV, do whatever they can, but now that's having to count as on-duty time.
Yeah, we restated the exception that was put in place by the ICC 50 years ago to
When was it?
allow special equipment that requires specialized training to operate in the oil fields, an exception from the on-duty not driving time. The entities that were excluded from that from the beginning and today now, since they're operating in much higher numbers, are generally water trucks and sand trucks. Now, again, we had a comment period. We received lots of good input.
We always
Yeah,
have.
that's
I almost crack up all the time when I hear agencies saying we had a comment period, comment period, comment period. It doesn't. The fact is that the industry rate has went up. The trucks on the road have increased, and we have wrote letters to you. We have got zero reply. We've introduced a bill and have got zero comment from you guys on this. Now, with that being said, before my time runs out, Mr. Hinkle, you made a comment that you'd think we'd be smart enough to figure out exemptions on this when we're talking about 30-minute downtimes. That doesn't always exist in D.C. I'm sure you're probably aware of that. But Ms. Ferro, you made several comments suggesting Mr. Hinkle and the concrete company of how they could do things. Have you ever been in a concrete truck? Have you ever been to a job site? Have you ever ran a full 24 hours with any construction company?
No.
So for you to make suggestions is saying that everybody that graduates from a college with a business degree is going to be successful in business. You talk about these researches and these studies and all this, but you have had no practical experience yet. Until you have practical experience, what you've learned in college and what you've learned from research and all these studies, it's just numbers and it's just paper. It doesn't really apply yet. My suggestion would be, why don't you go and visit the job site? Since you're the head of the department, since you're the one making these rules, why don't you go to Mr. Hinkle? I bet you he would allow you to run one day in his company and see what he's talking about by this time that is waiting. These individuals, why it doesn't make any sense why someone would have to stop for 30 minutes when they stop every hour, or why they're sitting there waiting for their truck to be loaded. Why they would all of a sudden have to stop. What would be so hard about you actually going and getting hands-on experience other than just having studies? You'd probably learn a lot more.
Nothing stops me, and I look forward to the invitation. And I will say I have been several times reached out to your office to meet with you to talk about the very concerns you've raised, and for some reason
ma'am, I've never got I would assure you I would meet with you in a heartbeat. In fact, we could meet tomorrow morning, because I have never had your office reach out to me that I'm aware of.
I'll look forward. We'll call and we'll set that up.
Okay.
Thank you.
Thank you.
Mr. Barletta.
Thank you. I'm probably not one of the last people you want to speak to right now, because my family was in the construction business, asphalt and concrete. You know, when people ask me about Washington, I have a common phrase I usually say is that common sense is not so common in D.C. And this hearing is pretty interesting because it reminds me of one we had last week about a rule. And I had a big problem with the rule. It was with HHS, and Secretary Sebelius tried to defend a rule that anyone under the age of 12 could not qualify for a lung transplant, that you had to be 12 or older, in spite of the fact that the little girl that I was advocating for was 10 years old. She had approximately 3 weeks to live. Her doctors at Children's Hospital in Philadelphia said that they could take an adult lung and modify it. This girl would have a good chance of living. However, the Secretary defended the rule that you needed to be 12, and we were okay with letting a little girl die because she was only 10. Now, I know this hearing is not at the same level as that, but it reminds me of that this is not practical. I understand what you're trying to do. My family was in the concrete business, was in the asphalt business. I had a line painting business where our drivers would drive 2 hours to a job site and sit on a job site and wait before we could paint the lines. When you're dealing with short haul or businesses like in asphalt and concrete and line painting, and there are many others, the rule, if it doesn't make sense and we don't have the scientific data to claim that it's going to make anything safer, why do we do it? Why can't Washington sometimes just use practical, everyday, common sense and still try to achieve the goals of making our roads safer? I offered an amendment to keep heavier trucks, triple trailers off the road because I had a problem with safety. So I understand what you're trying to do, but it just doesn't make sense for so many businesses.
Congressman, I appreciate your comments, and I think I join so many in being impressed by the advocacy you exercised that saved that little girl's life. And I would suggest that today's hearing is just as significant because you're talking about 4,000 lives. In the case of this rule, 19
But do you have scientific data to back that up?
Absolutely. And
That the 30-minute rule actually...
30-minute break.
30-minute break.
Yeah. Absolutely improves the ability of that operator to operate more safely, to minimize the risk of any kind of cumulative fatigue with that quick 30-minute break. They're more alert behind the wheel. They're more ready to respond if someone does.
Well, how do they? I guess I just can't understand how they can do that study when you're delivering asphalt. You're driving the truck, then you're getting in line, waiting to back into the paver. Driver's sitting there. How I just don't understand how they assess a 30-minute break when there may be periods of breaks throughout the day of every day. It's different. How did they accomplish that?
Well, it sounds as though we're not that far apart. Certainly, I've watched many a construction site. I've certainly been around a lot of construction folks. And you and Mr. Hinkle both identify the number of breaks that operators are taking just by virtue of the cycle and the schedule and moving product quickly and moving it fresh. And then going back for more. I don't think we're that far apart in understanding how those breaks work in that operation, and that's I'm not sure where else to go on that point, other than again to reinforce.
But how does another 30-minute break, when there may be periods of breaks throughout the course, how does another 30-minute break increase the safety?
It's not another. It's taking advantage of existing breaks they're already taking. It's the simple fact that the break itself improves the safety performance of that operator after the break, within that first hour after the break.
So even if they've had 4 30-minute breaks during the course or 5 30-minute breaks, adding another 30-minute...
They don't need another one. They only need one. They only need one. Under this rule, they only need one within the 14-hour workday. And it's got to occur sometime before that operator gets behind the wheel after the 8th hour of work. Just one under this rule. So if he's already doing 4, if your guys were doing 4, my gosh, they're way ahead of the curve, and they're probably much more alert as a result of that.
So if they're just sitting alongside the road, waiting to unload into the paver, how do you enforce that? How do you enforce that? They're not keeping a log, so how enforceable is that? That's
the challenge. It gets back to Major Savage's point. The enforceability generally comes through compliance reviews, in this case, until we have electronic logs in place. Now, in the case of those operators, because again, you're right, they're not keeping logs, they need to measure it within their normal timekeeping system.
Well, how would you enforce whether or not somebody complied or not? I mean, there's no record of whether or not, so basically it's up to the driver to say, I didn't have a 30-minute.
It could be driver interviews. It could be
how else other than that? How else other than that? If there isn't a log, could you determine whether or not they had the 30-minute break or not? Other than the driver, how else could you determine?
Well, again, I mean, Mr. Savage can speak to it because he's spent a lot of time doing compliance reviews and more inspection work. Thank you.
Mr. Chair, Congressman, there's 2 ways that I would suggest we could enforce it. One would be to provide the enforcement officer with the ability to enforce it by making a requirement that they keep supporting documents on the vehicle to confirm that the driver may have taken the time off. And the other thing is to increase enforcement through the MICSAP program, which is a particularly effective program, and making sure the states are fully funded so that they can do the good work that the officers are doing on the road.
Thank you.
Thank you, Mr. Chair.
Mr. Davis.
Thank you, Mr. Chairman. Looks like I'm it. So your day is almost over. First off, the benefit of being in freshman row here and going last is that most of my questions have been asked already, so I will not be redundant and ask them again. But thank you to all of you for being here today. Administrator Ferro, I actually want to say thank you. I want to say thank you on behalf of the ag industry in my district and the rest of the country for quickly issuing rules under MAP 21 exempting our ag producers. It's extremely important in my rural district. Secondly, though, I'm wondering if the FMCSA has considered exemptions or the issues faced by other companies that are involved in helping ensure that our crops get from the field to our elevators out into the global marketplace. For example, in Atwood, Illinois, in my district, a company repairs grain elevators. And during harvest, their techs can spend up to 5 hours driving to a site, 2 to 3 hours for repairs, and then driving home to be ready for their next job in the morning. Because of the weight of their trucks, they're included under the HoS rules. And in a letter to my office, the company's owner, Mr. Harris, wrote about the impact of these regulations. And I'll quote him. He said, "As you can see, driving hours accumulate quickly. Should we get caught, one fine could put us out of business financially. On the other hand, not responding ASAP to our customers' needs spells disaster for our business. Losing one customer can mean losing all the individual grain elevators owned by that company." So my business owner's in a conundrum. I mean, we've helped one portion of the ag sector with the exemption. Are there any ideas, any other opportunities we can have to make it a little more flexible for those who work in that same business?
Congressman, first, thank you for your recognition of the agency's work and for the nature of that question. Of course, my starting point is to encourage all operations and operators and business owners to look at their operation and their customers' needs and work them within the pretty broad hours parameters that exist today. That's my starting position. Understanding that, the agency does have, and the law allows us to have, an exemption application process. Any individual company, or in some cases a sector, can apply to the agency for consideration for an exemption. And we will examine it. In some cases, some of these exemptions we're talking about, like the ag exemption, is enacted by Congress. In other cases, there's this broader authority. The condition we start from is that should an exception be granted or an exemption be granted, it's got to ensure that the operating condition is as safe or safer than the condition today. And so that inlet, I should say, to the process exists today, and I'll be happy to follow up with your office and make sure your constituent has a clear understanding of what that process is. It's spelled out on our website.
No, I appreciate that. Speaking of that, how many exemption requests do you get on an annual basis?
Well, I will have to follow up. I can either lean out to my helpline here if...
Go ahead. I used to be part of the helpline.
Thank you. Larry Minor, does he... 10? Thank you very much.
10?
About 10 per year. Yeah.
About how many of those are approved?
About 20 to 30%.
20 to 30%. So
now, that's outside. Oh, pardon me.
Oh, that's all. No, you're
yeah,
fine.
that's outside of the exception process that drivers apply for routinely for a vision exemption or a diabetes exemption. Those are a different process, much higher numbers. But in this case, it's. Did I say a vision? Yeah, or a hearing. In this case, it's about 20 to 30%.
Okay, yeah. So about 2 to 3 a year out of 10 on average. As my time's running out, and I know you all want to leave too, can you provide my office with a listing of what those exemption requests were and the ones that were granted, so
Certainly.
we can kind of get an idea of what to expect when we tell constituents about that process?
We certainly will, and we're required to post everyone in the Federal Register, and we will provide all of that to your office.
Well, thank you very much. Thank you all. I yield back.
Thank you. And I'd ask unanimous consent the record of today's hearing remain open until such time as our witnesses have provided answers to any questions that may be submitted to them in writing. And unanimous consent the record remain open for 15 days for additional comments and information submitted by members or witnesses to be included in the record of today's hearing. And without objection, it's very easy to get unanimous consent if you wait. Beyond that, I really thank you all for a civil, somewhat contentious, but very important discussion, and we hope it'll help work things out as we go forward, and in a way that continues the improvement we've seen in highway safety over the last 10 years. This hearing is adjourned.